There really are no mistakes that a client can make, um, because the clients, before they even become a client, they approach a lawyer and they tell the lawyer a little bit about what's going on, or a little bit about what happened. And then it's the lawyer's job to say, oh, you know what? I think you actually do have a case here. But for instance, if a person comes to me and says, I would like to file a personal injury lawsuit, I fell when I was at work, and it was my employer that was irresponsible for keeping some liquid soap on the ground. My employer never cleaned that up. Well, what I would do is I would tell that person, well, you can't file a personal injury lawsuit against your employer, because if you got hurt at work and it was caused by your employer, that's a workers' compensation matter. And in California, there is, it's called exclusive remedy. If you get hurt at work and it's the fault of your employer, your exclusive remedy is through workers' compensation. You can file a lawsuit, or if you can find a lawyer that will file a lawsuit on your behalf, but I can almost guarantee you the courts are going to dismiss your case because it's a workers' compensation case. Now, if you're at work and there's somebody that has come into your workplace. So, for instance, a UPS person or someone from FedEx comes into your office and they do something that is negligent and it causes you injury. Well, you then could file a lawsuit against that person in the civil court system, because that person is not your employer. They're visiting your business, and while in the course and scope of doing their job, they did something irresponsible, reckless, or negligent, then you could potentially bring a lawsuit against that person.